Yes, over to boardroom.
Good evening, all. It's my pleasure to welcome the resource person of the day, Dr. Professor Dr. Devanshu Shrivastava. Dr. Shrivastava is an ardent academician and zealous legal researcher, having 12 plus years of teaching experience. After having cleared his UGC NET in law twice and also MP set, he completed his PhD in intellectual property laws from Barkatullah University, Bhopal. Apart from this, he also holds a diploma in cyber law, diploma in medical laws, in media and drone laws. He has various certificate courses from WIPO, University of Penn, in his field of study, IPR. He was the founding head of Central India's first and only public policy school, Jagran School of Public Policy and International Affairs at Jagran Lake City University, Bhopal. He's an active member of various editorial boards and a lifetime member of national and international journals. He is on the advisory board of various legal platforms. He has also a great experience of participating and in conducting of debates, moot courts, ADR tournaments, policy dialogue, legal aid camps, and various other like activities. He has won the prestigious Excellence in Research Award thrice in academic year 2015, 15, 16, 16, 17, and 17, 18. He was also awarded with the Outstanding Performer for the Year Award in 2015, 16. He was felicitated with the prestigious Excellence in Research Award in 2018 and the Best Faculty Law Award 2019 by Arjun Das Gulati Foundation in collaboration with Allahabad University, Allahabad. He received the prestigious Best Faculty in Law at the International Academic Awards in Dubai, presented by GISR in the American College of Dubai in October 2019. He's been awarded with prestigious BW 40 Under 40 Legal Awards for his contribution to legal academia in 2024. Dr. Devanshu has been very actively acclaimed for his editorials in various leading newspapers and is a regular invitee as a resource person at various national and international gatherings. He has been a trainer for leading government and non-governmental organizations. Dr. Srivastava is proudly serving as the founding dean and professor at GL Bajaj Institute of Law, Greater Noida, India. Today, he shall be dealing with the topic best practices and innovation in ADR. It is my privilege to welcome you, sir. And I would also like to welcome Dr. Kalpesh Kumar Al Gupta, founding member of Pro Bono. With this, I think we can start the session today.
Yeah, thank you so much for that invite. And thank you always to Dr. Kalpeshwar sir, who, and I'm at all various forums. One thing that I've always been appreciated of is the various mechanisms through which the awareness, the teachings, and the research about not only the coming or the very new areas or avenues of law is being taken up by law teachers group, the pro bono group. Also, when I was invited to be a part of this 10-day online capacity building program on ADR, legal aid, and allied laws, jointly organized by JSS Law College and Pro Bono. Now, the only thing that excited me is to bring ADR, legal aid, and the allied laws together. And I know not much would have been talked upon because all three have been talked upon in Xylos about how ADR is working in our country, how legal aid and the allied laws are there. In my presentation today, and I've been told that today we are also followed by the valedictory ceremony, where Honorable Professor Dr. Manoj Sinha sir would be joining us. Now, I keep it short, but it's my duty here to tell you the reason why this idea was incorporated and keeping all the three laws together. Because there is indeed a very, very critical connection between the same. Now, when we talk of ADR, I know there is, and in this present contextual time as well, there is a lot debate regarding ADR. Does it really stands for alternate dispute resolution? Or now the time is there where we need to change the meaning of ADR to very important thing, that is the additional dispute resolution, or the most important, that this is a dispute resolution rather than the dispute resolution as we have been seeing on to. Again, when it comes to legal aid, ADR mechanisms have been playing a great role in providing legal aid. Um, and as I come across, and I've always been explaining in my legal aid practical classrooms as well, that why legal aid was used, why in law we resemble first aid given under the a particular thing to a legal aid thing, and that's how ADR would always be on that particular point. So my only thing would come that it should be legal aid, ADR, and allied laws, because that's how a role of the ADR comes into play. And looking forward towards the allied laws as we were seeing together. So on this very important note, I would like to bring ahead that how the concepts have been brought on to, and how the areas that we are going to see today. I'll quickly take a second to move towards my presentation. Um, I hope I can share it. Just allow me a second, please. Okay. I hope my presentation is visible to everyone.
Yes, sir.
Okay.
It's
And can you just quickly let me know, can you able to see the slides getting changed as well?
yes, sir.
Okay, perfect. So on that note, I welcome you all once again to this, the last day. And today, as the topic itself is talking about the innovations and how are the best practices in ADR prevalent. Now, I can directly jump to the topic as well, but I guess that would not be that fair enough. So my starting slides are something which, and as we generally do on the last day, it would be a sort of a recap of what we did in the past 9 days as well. So alternate dispute resolution in the transforming legal landscape, I'll tell you, is number one, it was brought, and why it was called as alternative. Um, is only that because from the court side or the dispute resolution mechanism we see across, it was number one brought, number two decrease the numbers of pendency or the backlogs, and second was to improve the access to the justice. Now I can also tell you that the parent law that I can generally recall was not the Arbitration and the Conciliation Act of 1996 for an alternate dispute resolution. So the Arbitration Conciliation Act 1996, prior to that, we did had the Legal Services Authority Act, which by the mechanism of legal aid, lok adalats, and other such mechanisms have brought ADR into perspective. And that also was not merely that an act was constituted in our country and given up a shape. No, it was then well incorporated under Section 89 of CPC. Now, if we'll see the chronology, we can always understand. And to when I was told is that we also would have young legal minds in form of our young law students, some brilliant one. Now, you need to understand that why this was brought into shape. This was brought into shape, and why under CPC Section 89 was incorporated. Again, Section 89 CPC was not the part of the original CPC 1908. So Section 89 provides the court this particular advantage that the court can refer to the five of the mechanism which is provided for a civil dispute to be resolved. Now, ever wondered why this was made as a part of the Code of Civil Procedure, the only procedural code on civil matters? So, Section 89 provided for the five mechanisms through which, apart from, alternatively from the courts, the matter can also be resolved, number one, plus with the same sanctity, with the same power, with the same bindingness. And that's the reason why Section 89 was incorporated. The only difference then why in further, when I'll move ahead, why Section 89, which was majorly a court's power to take it up, was also alternatively be taken under with the Arbitration and the Conciliation Act 1996, amended in thrice now. And then the recent addition being the Mediation Act itself. So the rapid evolution in legal and business environments have been demanded for the innovative solutions to the long outstanding challenges that we are seeing already. Now, what is ADR? ADR is comprising of arbitration, mediation, and conciliation and the Lok Adalats Act for present in our country. Now, I know there can be questions of what about the negotiation. To be very honest, negotiation is still an uncodified aspect of the alternate dispute resolution which we see in our country. I'll repeat, negotiation is still an uncodified aspect of the dispute resolution in our country as well. If I'll see the four which is mentioned on your screens right now, which I've highlighted as well, we all know what an arbitration is. The past 10 days emphasizingly on arbitration and mediation have been given on. Now, the basic components involves that this is basically a private thing. Why it differs from Section 89? Yes, it is parties' power. Nowadays, all major contracts, which involves a foreign party, which even involves Indian big corporate houses, have compulsorily now started putting an arbitration clause in their agreements. Now, this also fades away the old concept that there can be two mechanisms by which an arbitration agreement can be given into force. Number one, it can be an arbitration clause in the contract or the agreement signed between the parties, or a separate arbitration clause giving a addendum value towards what the agreement was all about. So this is basically private. Private, when I say, it's between the parties. Also, before I move ahead, a caveat, all the mechanism that we are talking, we'll have to keep in mind why only CPC got amended with Section 89 and not CRPC. This gives us a blanket thing to understand that ADR mechanisms are only applicable towards the civil disputes. And under the civil disputes as well, no criminal matters. So criminal matters are outside the purview of ADR. Secondly, the tax matters. And with that, we will come and see in detail that when and why the tax matters have also been kept outside the purview of it. So being the basic nature, arbitration is a private matter, a binding decision given by an arbitrator, which is chosen by the parties. It would always be odd. That's how the tribunal would consist. So the tribunal can consist a minimum of one and a maximum of an odd number of arbitrators there. It is very common in the commercial disputes, and today it is now being developed as well. And then when we see the forms of ADR, the forms of arbitration, as you people are aware, the ad hoc, and nowadays, which is more prevalent, is towards an institutional arbitration. I will come to a couple of recent things that have happened. I'll wait for my second last slide for that recent amendments or the recent legal scenarios, as we will be talking about more, that has brought into shape. Second is mediation. And again, compared to the arbitration and conciliation in our country, mediation is still a very new baby. But I'll be very happy in saying this, that as soon as this young baby was coming into existence, I guess it has taken a good shape as well. The younger it happens to be, but something which was, I guess, very well known. I am only calling it young because of its date of enactment and nothing else. Now, major difference between arbitration and mediation, it is facilitated by negotiations where a neutral mediator helps the party to reach a voluntary agreement. Now, what's the difference between an arbitration and why I've never used the term voluntary agreement or the voluntary solution in an arbitration? Because it was more of an arbitrator giving a solution. In mediation, the mediator eases out and parties themselves gives the solution. Mediator never gives a solution. Mediator only helps the parties to reach a voluntary agreement between them. And I'll make you understand, and I know there might be many questions popping up. You can either use the chat box for your questions. We'll try to answer that all at the end. Or you can even unmute yourself at the end and have your questions taken. Then comes conciliation and Lok Adalats. Now, why, very importantly, and I'll be very honest to you people, I come from a family of lawyers. On a very lighter note, I say that my blood group is LLB positive because I'm a fifth generation lawyer and a first generation academician of law. Now, when I say call myself as a fifth generation lawyer, I by no means I'm calling myself an advocate. I am calling myself as a lawyer because I can only have an advisory power and I'm not practicing advocate. But something that flows in, and my father is a civil side advocate. It's been more than 43 years of him to practice. My brother is a practicing advocate at Allahabad High Court. And the two things that I've seen even prior when I was a law student, when arbitration and conciliation was just an optional subject to be taken on to, I saw lok adalats happening. Not at this stage, which is happening, which is more than a festival or something like that, where each law student, I guess, in any part of their country, in any law school, be it so it's a national law school, be it so it's a central or state university, or some very initiative concepts like this autonomous JSS Law College as well in Mysuru, I'll tell you, we were not that aware, okay, that a Lok Adalat is happening. Why I was only aware that a Lok Adalat is happening? Because these were those particular Sundays where my father was not allowed, or I'll say was not available at home spending time with the family. But these are those Sundays where he had to go to the courts and to get the matters resolved. And I'll be very clearly, I was in my first years and I went back for my vacation to my home. And I asked my father, you seem comparatively very chilled out on going on a day, and you're not also properly like the entire uniform, the bands, the coats, and everything. And when he came back, he was like, okay. And I, out of curiosity, I asked, how many cases did you solve today? And to a matter of surprise, he said 28. Now, a law student who was very curious was like, okay, I have been hearing on the news that it takes ages for the civil suits to get disposed of too. And here you are standing in front of me and saying that you have resolved 28 cases. And he didn't answer me straight away. He said to me that, I'll tell you one thing. The all of the 28 cases that I resolved out today, or that were resolved today, are resolved forever. They would never be appealed as well. And I was like, okay, oh, this mechanism is very, very good. And how this comes on to. And that is how, for the first time in my life, I was introduced to the concept of lok adalats. And that's how Section 89 and that's how the Legal Services Authority Act comes into play. And this is a act which is out of the 5 settlement processes under Section 89 and as an alternate dispute resolution comes first. The 1980s form of an act where I see this thing. Also untalked, very, I'm not say less as well. The least that I've ever heard of is conciliation, although it came into existence alongside arbitration. You all remember it's the Arbitration and the Conciliation Act of 1996. But what has been missing out, and the only place there where, as a law student, again, I'm talking about 2005 to 2010, when I was a law student, I heard conciliation was the labor laws, under the labor laws. And I'm not talking about the labor code today. I'm just talking about more of the labor laws, Factories Act, Industrial Disputes Act, and so on and so forth, where I heard the term conciliation apart from the arbitration and the conciliation. That was the only two places I ever heard for the conciliation things. Now, when I move towards how ADR mechanism has helped us, is there are, and as per the data of the which is available now online, and you as law students can definitely track on. Also, one of the reasons why I'm mentioning that, please see this portal which is managed by the Supreme Court. Uh, that tells you the real life pendency cases, state wise, district wise, case matter types, civil, criminal, whatever it is, high courts, Supreme Courts, all together at one particular place. If I guess the time permit, I would try to showcase you also, which is that site where. And the reason why I'm telling you this as a law student, that tomorrow if you cite, or if you're into researching and you want to cite a matter regarding the pendency of cases, regarding any such things, please refer to this website, as this is the most authentic first-hand source that you can refer on to when you're citing with the number of cases to be pendency. Now, the evolution again in our country was nothing, as you can see as a very valid picture in our thing, is the Panchayati Raj. And I'll be very honest, being coming from a background of where majors we were studying, I am a student from a Hindi speaking belt as well. So we heard for the first time, and even today, the Hindi of arbitration or the Hindi of arbitral award is still in our country called as Panchat. And this Panchat hails its origin from the Panchayati Raj, or how the panchayats used to deliver the disputes of the village in that particular thing. Yes, it was a fixed number. Again, the things that we derived was it was always 5, the odd number to be taken on to, and this was survived by, or headed by rather, a sarpanch, and in our case that would be the principal arbitrator for our arbitral tribunal. Early modern era, for the first time, we only saw the Arbitration Act 1940. But to my surprise, again, when we already had the Arbitration Act 1940, the purpose of incorporating conciliation in the and repealing the 1940 Act and adding the conciliation in 1996 Act, I guess very less emphasis till date has been given to the process or the concept of conciliation. So, but I'll tell you why this was brought onto. This was only brought because of the UNCITRAL model law that India signed. And as a matter of fact, India need to incorporate. That's again the power, law students again. Any time a country, and specifically a country like India, signs an international treaty, international agreement, international thing, and if there is a provision that they need to incorporate their municipal laws, so by the purview of international law, India being a sovereign country, nobody can bind us to make a particular law. And that's the reason why when we sign an international treaty, UNCITRAL for that matter, TRIPS for that matter for IPR, under the purview of Article 51C, and this 51C is not a sub article or an article, it's a clause under Article 51. So when this is the last article of the part 4 of the Indian Constitution, the part 4, which is titled as Directive Principles of State Policy. So by the power vested under Article 51, Clause C, this is a small c, that if India signs any international treaty, it has to bring these changes according to the municipal laws only. So India signs a treaty, the parliament has to bring, rectify, amend, or altogether bring a new law. In this particular case, ancestral being signed, India enacts an Arbitration and the Conciliation Act 1996, incorporating provisions like New York and Geneva Conventions and repealing the 1940 Act. And today's time, where I guess post 1991, where the LPG, the liberalization, privatization, and the globalization model has expanded, opened the gates. Very recently, even the FDI investments were allowed, allowing foreign countries or the foreign companies to invest more in India or having their offices in India, opened a huge market where international influence have shaped the India's ADR landscape to meet the global standards. Where so it can be institutional arbitration of world standards, like in the form of SIAC, the Singapore International Arbitration Center, or the London International Arbitration Center, or nowadays the popping up things are from Dubai as well. So India's dispute resolution traditions have a blend of ancient customs and with a modern legal framework. And as I said, the major two forms of arbitration that we see in our world today is ad hoc, where India has spent major of its past decade over our ad hoc arbitration. But the coming times is more and more of the institutional arbitration that we are going to see ahead. Now, as I said, how and what all things were there. So the ADR mechanisms which are covered is just like this pyramid on your screen. And it covers majorly on the top. As I said, this is an inductive or an inducive method where majors are derived from. So yes, the top would be held and taken up by arbitration. It's a formal binding process for complex disputes, but not evolving more and more of the court matters. You would not find majors of how the ratio and the obiter would be taking up into place. It's more of between the parties. The new and the very evolving concepts of mediations. And till far, the most successful model, because you remember the first slide I said, why alternate dispute resolution was brought and so overwhelmingly accepted in our country by the courts as well, is because of the reduction of the number of cases. So next time you see a national Lok Adalat happening, which is a date where across India, the Lok Adalats will happen right from Supreme Court to the lowest of the district court in your particular city or taluka. This particular mechanism of alternate dispute resolution till date has solved the maximum number of cases when it comes to numbers. And with an advantage that it would not be appealed on. So next time, as law students, I humbly request each one of you, even if you are getting, I know it generally happens on a Sunday or some often holiday day, but please, please, please take out time and attend these Lok Adalats, where you'll find more of a camp thing initiated, and companies are happy, the litigants are happy, the judges are happy. So, as I say, and as I can quote, uh, you can see in one particular day, that is December 2023, the National Lok Adalat resolved nearly 14.23 lakh cases in the country. Now, I know that we need more of these days. Can we make it frequently? Can we make it again? Everything comes with a particular time, with a particular thing. So, National Lok Adalats at present in our country happens in each quarter once. And that has brought a major change, and I'll urge each one of you to be a very clear part of it. And in my last slide, I would also like you as law students, how you can start early in your own law schools in bringing these changes as well. And then comes the last on that pyramid, the conciliation and the tribunals, where more of the procedural laws made. The tribunals, when I say, I mean it's more of a quasi judicial body, and they have a specific form of a dispute mechanism. These tribunals are generally constituted by an act, which can be a state legislature or a central legislature. And the dispute resolution mechanism is also provided in this same thing as well. Now, moving towards how the new technology is making India as well to shape it up, is the answer of institutional versus ad hoc arbitration. Now, to institutionalization of it, the two names, as you can see in short forms available, are MCIA and DIAC. DIAC is very, very popular. Even, and I really credit the government of bringing the recent amendments under the Arbitration and the Conciliation Act, the 2019, the 2020 amendments. They have brought institutional arbitration, and for all of us, and I'm really happy for my younger generations to come up from the law schools. By the time you people are on the verge of your graduation and you're graduating, believe me, India has established itself and has made a mark. I'm not saying that they have established at the top of it, but established itself as an institutional hub, and they have made a mark on that relay race where institutions like SIAC, London institutional arbitration, and Dubai institutional arbitration have taken a lead. But yes, India has now made a point. So with two MCIA, that is the Mumbai Center for International Arbitration, Institutional Arbitration, and the Delhi Institutional Arbitration Centers, they are coming up with their own providing structures. Now, we all understand what is a major difference between how institutional arbitration would help up. I'll tell you, look, there are many colleges which are affiliated with KSLU, but why JSS stands are different because of a mechanism that your college has been adopting on. It has its own way of institutional addresses. It has a way of how this wonderful presentation, and I'm very happy, and I'm like complimenting the JSS Law College for bringing this huge number, which I am seeing on my screen, increasing day by one, and at present what I read is 150. So it's a big compliment that this discipline, this entire thing, that even at 7:30 in the evening, the college and the students are serious. So this is all an institutional framework. So if I can make you understand this way. Similarly, the institutional arbitration comes up with a set of it. It would be that, okay, who can be an arbitrator? All arbitrators would behave in a I will not call it a behavior. I will more call it towards that how they are um, trained to resolve a dispute. It has its own reasonings. The place of arbitration is decided. The rules of arbitrations are well framed, and all are abiding the same thing. So it's more of an institution. It's more of a temple, a more of a particular society with a developed rules. If I can bring jurisprudence out there, and I hope you people remember how Austin defined that yes, when I'm talking about the analytical positivism as a school which he established, and he said law is nothing but a command of sovereign backed by sanction. And he parallelly said that international law is nothing but a law of clubs. And why law of clubs? Because it lacks sanction. But the institutional arbitration is exactly the law of clubs, but it has its own sanction, which has an equivalence of what the sanction of court of law has. And that is how the concept and the jurisprudential analysis of it and advancing towards how they have been formed. So for me, institutional arbitration is resembling the definition of Austin, that law is nothing but a command of sovereign backed by sanction, where the institutional arbitration is in itself a sovereign body. It has a professional case management process, right from filing, everything is defined. What would be the time period? What would be the fees? All things said and done together. Standardized rules and procedures, higher initial costs, because that's how things are defined. Also, who can be the member of it? And I'll give you examples like SIAC. I guess we all recently saw a news floating worldwide that there was a former Chief Justice of India who is a member of SIAC, and there was a judgment process and how those things were coming on to. Now, why this was there? Because SIAC, being the prime of what an institutional arbitration is all about, even Indian members, both from bar, the bench, are the institutional arbitrators empaneled with SIAC, and that's how they are getting on. On the other hand, when I see the ad hoc arbitration, I am coming to a point that they are customized according to party needs. So, what was the major difference? Institutional arbitration is common, it's a standard process. So, it's more like, okay, a flowchart has been defined. So, if I have to get inside the house, I'll go, ring the bell, the gate will open, I'll get inside. On the other hand, ad hoc arbitration is more of a customer. It depends who is at the door. So if A is at the door, he can jump the gate and get inside. Nothing happens. If B is at the gate, he needs to ring the bell, then the gate would open and then a person can get. And if something else is, there is another back gate. So no standardized process. It's more of a customized project. The procedures are, again, if the rules are not set up, then automatically what it helps us, that there would be a customized procedure, a flexible one. Flexible when I say not rigid, but as what it is. It initial costs are less, but more party management is required. At the end, when the things are more flexible, the judgment or the award which is given by the tribunal or other things would not have, and it would, again, the provision of challenging that in court. You remember the section 34s of it, that set aside an award, you can go to the court. Now, if you again have to go to the court, how can I call it as an alternate dispute resolution? I'll have to call it again dispute resolution through courts. So the purpose of alternate dispute resolution was that you need not to go to the courts again. And that's again where you'll find me again and again saying that why I'm a big fan of Lok Adalats happening. So setting aside is more and more possible in ad hoc arbitration, while less in institutional arbitrations. And as you can see, the market trend, and that's the purpose why I brought it here. Institutional arbitration grew 47% from 2018 to 2023, the 5-year gambit that we are taking also, as the businesses sought reliability and consistency. I understand that it might have some higher initial costs, but it is more reliable, more end-to-end driven, no more appeals, no more other such things. So alternate dispute resolution in true sense becomes an alternate dispute resolution. Now, how these technological innovations have been impacting ADR. Nowadays, ADR is no more ADR, it is also called as ODR, the online dispute resolutions. I'll be very honest, as a student of law, and I still call myself, I was so humbled when I was being introduced with all those things. But believe me, I still believe myself to be a student of law. The only fact that it's only a couple of months for me that I've now been a certified arbitrator. In the past 2 months after being certified as an arbitrator, being empaneled with one of the institutional arbitration centers in our country, uh, I have resolved 3 of the arbitration proceedings as a sole arbitrator. Now, and this all has happened, me sitting here, the parties in the three disputes have been with the different parts of our country, and the matter have end to an award, and as the good part, it was settled between the parties, and the parties are very well satisfied with it. The point is not with me. The point is with that institutional arbitration, which has a set of rules. So, as law students as well, I will urge each one of you that you can utilize this concept of it's irrespective of age. I know all of us are here in this particular domain above 18, and that's an only thing on to. I'll add one more thing that why, as a student of IPR, what attracted me to take ADR, and this was something I was discussing with Kalpeshwar sir the other day as well. Now, what has helped me to take, and for that matter, I am a certified mediator first, then a certified arbitrator. And I have done mediations, I have done arbitrations in the IPR disputes. So, where I am the an obvious choice, because being an IPR scholar, any matter between two pharmaceutical companies for a patent of their product, a pharmaceutical patent that I'm reflecting onto out here, I was the sole arbitrator. Okay, like this person knows about what a subject knowledge would be all about and how those particular things would be taken on. So the virtual hearings, and I guess the only positive thing that COVID-19 gave to all of us was everything moving towards an online mode. Online certifications were emphasized. UGC, for that matter, has allowed 30% of the syllabus to be completed in an online manner. Online certifications like these of arbitration, conciliation, on your own way of doing it, DIY concepts, and all those things have brought a good change. And the ODR mechanism has nearly conducting of 65% of the cases in an online manner post 2022 as well. E-filing system in all the courts have become a mandate. Now, what this e-filing has done, e-filing has done the same thing of what e-registrations of the property have done. So today I need to buy a property in Bhopal, or for that matter in Mysuru, which is a beautiful city. I just need to go to the website, check an e-registration of what the property is all about. Is it registered with somebody? It is a government property, and that is very clear with it. Similarly, when a plaintiff or a defendant files nowadays, major of the high courts in our country have incorporated. I'm sitting in this part of the country where both I'm sitting in Greater Noida, which is a part of Delhi NCR, which is also a part of Uttar Pradesh. And I can proudly say both the high courts of the state, Delhi High Court and the Uttar Pradesh or the Allahabad High Court, um, have incorporated an e-filing system. Now, this has reduced the cost, this has reduced, but it has brought a reliability as well. Now, moving towards the successful ODR platforms which are there and which you can resolve onto. First and foremost, Pre-Solve 360, SAMA. Then we have IIAM. And IIM is very recently launched a great app called as PeaceGate, which is their online dispute resolution mechanism and a platform which helps to resolve matters for that particular way in an online manner. So cases are taken on a virtual hearing. The time limitation of what has been provided under the amendments of the 2019 or the 2020 of the under the Arbitration and Conciliation Act of 1996 is taken care of. Under those paradigms, institutionalized arbitration of IIAM is there, and that helps you to resolve those things. So these are few of these things. CODR, again, they lead the Indian online dispute resolution ecosystem for that matter. So I'll repeat: Pre-Solve 360, IIAM, PeaceGate, that is inbuilt with the IIM institutional mechanism as well, SAMA and CODR are few of those things where you can definitely see and take on to. Also, very importantly, that I like to mention out here is that as law students, specifically the law students at JSS Law College here, now we all cannot take away technology. And I'll again urge both as a law teacher and as a legal scholar that technology, as I said, as I'm writing that on the bottom of your screen as well, that it democratizes the access to justice. Now, when I say it democratizes the access to justice, It's like technology has brought justice for all. Again, I know there are questions like, sir, are these apps, the AI tools, they are initiating the ADR mechanism for that matter? The answer is yes. And I will again recall a real incident as well. Peacegate, as I was mentioning of IIAM, is one of those particular platforms which is AI enabled. Now, as law students, I'll again urge, let the AI tools be at your fingertips. Use it as a tool. When I say use it as a tool, do not rely on it, but please utilize it so that your work gets easy onto, but apply your human brain onto. And always remember the bottom line, it is the human that created an AI app and not a vice versa. So it's not the AI that is creating humans. When I say this, what I mean that use it as a tool. Use it as a normal tool like a laptop, a screwdriver, a hammer. So each tool has been given to utilize or to ease on your work. Similarly are the AI tools. So it would improve your efficiency while reducing the costs for many things. Now, as you can see it on your screen, this is the Niti Aayog's data that is showing how the increase, or I'm so sorry, how the increase of the ODR mechanism has been taking place in our country. So this is how the rampant increase, and I'm sorry for this figure, the bottom represents the years, and I'm talking about 2018 to 2022 to 2023. The tallest on your screen out here is the 2023 model that I was talking on to. The latest here that I can see is the 2018. So you can see a growth of nearly 160% that we can talk on. And this data is based on the Niti Aayog's report of how ODR mechanism is being increased in our country as well. Now, talking specifically with the mediation practice, three very important things. Again, the Mediation Act that we are seeing with the 2023 Act itself. The Commercial Courts Act. This is one very important thing in which a recent amendment has been proposed, and they have made pre-institution mediation as a mandatory for the commercial disputes. Now, the concept behind is that a pre-mediation is always an half of your work is already done. You as parties are very close to talk, and not only to talk but also to come to a solution, near end to the solution. So the under the Commercial Courts Act 2015, a recent amendment that has been brought on to, which brought the pre-institution mediation as a mandatory for a commercial dispute. Private mediation centers, for example, the camp in Bangalore, MP High Court State Mediation, um, Delhi Mediation Center, and recently there was a very beautiful judgment that in marriage disputes, a pre-marriage mediation is compulsory and should be given an advancement onto. This has helped, and learning from the mistake of the Arbitration Act 1996 to the 2019 or 2020 of institutionalizing the arbitration, the Mediation Act itself has brought the institutionalized mediation thing of our concept, and that makes the agreements more enforceable. So mediation's growing legitimacy stems from legislative support and infrastructure development. And when I say legislative support, it was number one, by enactment as in the Mediation Act, the amendment as in what the Commercial Courts Act was talking about, and the family law matters as well, and the infrastructure development. When I talk about the infrastructure development, I refer to the Camp Bangalore, the MP High Court State Mediation Center, the UP State Mediation Centers, the Delhi Mediation Center, and so on and so forth. The best practices, as I was talking about, for leading the sectoral examples are right on your screen. And I'll start with the one which is very close and very clear to me as well, in the form of how e-commerce leaders, where it's Amazon, Flipkart, Paytms, they have integrated the ODR system in their thing. You see today, and I'll give you an example as well when I talk about um, how the concepts have been taken onto, for that matter, is the component of how you ordered something, and I'll give you a very recent example as well. You order something. I do not know. I'm unsure whether Blinkit or such thing appears or is there. But let's take an example of Amazon. You ordered something from the Amazon. It was a default product that was delivered to you. Today, directly leading on towards the your customer care executive in person one, there is an automatic chatbot gets open for a customer care, and they would first try and to have a word with you and try to resolve it. This exactly is what the mediation, this exactly is what a negotiation concept of the mediation goes on to, which is a pre-dispute talk that is happening on to. They ask you whether you are satisfied or not. You either click yes. If you click a yes, the dispute gets resolved. If you click a no, then you get an option to connect with the customer care executive at that particular place. And even if that doesn't happen, you write an email to the customer care, they do not take an action in 30 days, you can file a consumer complaint for that. So it's not like that these mechanisms are closing the parameters, or they are closing your relief. No, they are just initiating the release. And for that matter, the legal executive of Amazon, a very dear friend to me, he only told us in a seminar that we organized a couple of weeks back itself. He said it very clearly that these things, the pre litigation mediation or the pre litigation negotiation through these particular mechanisms, have reduced their cases to nearly 68%. So, a welcome step where again e-commerce leaders have adopted that, and the names are very few that I have written on to. Add Zomato to that list, add Blinkit to that list, which is again a Zomato thing. Add Uber, add Ola to that list as well. Moving secondly, which I would be very happy to take, was also in the form of the finance sector. Now, RBI, the Reserve Bank of India, and also termed as the central bank of our country, has mandated ODR for NBFCs and bank disputes. I'll also recall a very important incident here, which happened at a DRAT. DRAT is the Debt Recovery Appellate Tribunal, and I'm talking about the DRAT Allahabad, that where ODR mechanism have been incorporated as a valid and a very efficient way to resolve the matters. The same thing once been done at the appellate tribunals, the DRT, the Debt Recovery Tribunals have also taken that particular point. This reduced the resolution time from months to days. And look how well the technology is helping to take or resolving this particular things as well. Another very recent example of what I saw next to me when my set of students were interning with the Delhi Metro Rail Corporation in their litigation and dispute department, Delhi Metro Rail Corporation, DMRC, has established rapid arbitration panels for many of the things. Now, this is not merely for a customer thing that I'm reflecting on to. I'm saying this is not only for the customer thing, but also, for example, the expansion of new phase of DMRC, where a land acquisition has to be done so that a pillar can be constructed or an underground metro can go on to. Now, this rapid arbitration panels, which is also called as RAPs, are very effective in resolving these particular land acquisitions as well. And as a matter of fact, which takes time of land acquisition, these rapid arbitration panels have reduced the time from very incorporating to a particular answer point. So sector specific, again, as I said, Gift City, as you might be aware of, in Ahmedabad, establishing and is on the verge of how aviation industry would be settling matters more with the online dispute. And there have been major cases of our country where aviation industry can be set up with that. Another important thing comes of how we are seeing a particular answer to the fact that yes, they have brought on to. I can also recall of how the arbitration amendments, the three majors one, from 1996 to 2015, nearly took 20 years. I'll be very precise, 19 years for the first amendment. And then you can see the rapid amendments both in the 2019 and the 2021. has done not only to shape the arbitration process in our country, the ADR mechanism to be strengthened onto, but also incorporating and giving emphasizing towards institutionalized arbitration and the time domain. Arbitration on in the mid has also become like a unruly horse, if I can use that word, in the terms of fees as well. The reason why common man was not even ready to approach arbitration because of the high fees and everything and the time thing. They said, you said it was an easier way. You said it was an answer to the delays that we were taking on to, and it was a cheaper. But sorry to say, arbitration in the mid went the court way itself. It was more of retired judges and everyone, or high paid lawyers. They were charging excess of the fees. The arbitration proceedings happening at 5 stars or the 7 stars of the hotels. The fees was getting on a very high thing. As a result of which, the amendments in 19 and 2021 not only shaped it up, but also put a cap and a limitation in terms of time period, in terms of fees, in terms of every such thing. So it improved the time limits, it reduced the court interference, and has sort of limited, I'll use a word, sort of limited with the fees things as well. Some very important, and one of those is the NN Global versus Indo Unit 2023, which which upholds the party autonomy towards a particular matter. Mediation bill, which recently shaped up as the Mediation Act of 2023. I have written that it has been passed, but awaiting implementation is only of the fact that the institutionalized system of mediation is still yet to see a day in our country, but that's how they are being taken on. So, with the point of how that particular thing was taken, when we move towards the next I is the key lessons that we are taking on to is also one of an important components when I see the components of how ADR in our country and the lessons that we are going to learn across is being brought on to. Now, post award enforcement average is 18 months. Now, one thing that India should definitely see on to, and this is the maximum time period I'm taking you on the verge of how we are going to take it. Rural and small business sectors lack awareness about ADR benefits. That's how even district courts and other such places, such ADRs have not yet knocked their doors. And if they have not been aware that no, no, no. I know advocates for that matter would never want a person or their parties to adopt for this, as in for their like the fees and other things would go on to. So this is also one of the reasons why, and this is one of the challenge that we under our system needs to be taking it on to. Now, if I'm talking about how the other component of to be taken on to, and with the paucity of time, I just want to show one very important thing. So these are the future trends that I was reflecting on to. And if I can see this particular thing, as I said, and I mentioned that very clearly, this is a recent thing which says a pre-litigation mediation under Section 12A of the Commercial Codes Act is mandatory. Any violation would lead to the rejection of the plaintiff court's judgment. Similar thing, 3 days back, one of the very important high courts in our country, the Delhi High Court, said in the marriage thing, the pre-marriage things, mediation is a compulsory element. And this is where I'm reflecting to Section 13 of the Hindu Marriage Act of matters of divorce and other such things to be brought on. As law students, I'd also like to emphasize Section 13B, the mutual consent divorce, which is again, if it is taken by mutual consent, it cannot be appealed, it cannot be taken on to. That's also one of the ways if the divorce is the only option. The link that I'm giving is the link from the Press Information Bureau, the government thing, and something what Shri Arjun Meghwalji, the minister in charge for the Ministry of Law and Justice, independent, has to say, and he said across when I'm becoming. So if I can just see if I can read on to this. He said in the parliament as an answer to a question that how the technology is being taken and what is the new age of ODR and ADR. He mentioned the Commercial Courts Act. He mentioned the Mediations Act. He mentioned the three amendments, the 2015 to 2019 and the 2021 of the Arbitration and the Conciliation Act to be a game changer, and most importantly is the establishment of the institutionalized sectors for ADR, which is whether institutionalized arbitration in the form of MIAC or in the form of MCIA or DIAC, or for that matter, the Mediation Council of India, that is also going to be taken on. Now, just to conclude it, ADR mechanisms in our rapid technology times, how ODR is nothing, I am not deviating from ADR. It is an ADR done in an online format. So that's the nomenclature of online alternate dispute resolution. I should say it OADR, but just for nomenclature, it's ODR. The rules, the institutionalization and everything remains the same. It is definitely for the enablement of the business and not the ending. Mediation, as it is rightly said, that when the two parties or the two businesses are ready to continue with their business, mediation is the best answer for them. I was also reading a very important quote this morning itself, and that was in relation to how the concept of mediation has taken up. He said that mediation is 1 ounce of mediation is like is equal to few kgs of arbitration, which is equal to quintals of litigation. And the reason is very clear, that what the quintal of litigation would be required to resolve matters is would be done by kgs of arbitration and would be done by 1 ounce of mediation. And the best part, that the business continues to remain the same, because number one, it is not a precedential judgment. It is between the parties and their legal heirs only, and they are only knowing when the dispute arose and when the dispute got resolved. So that's how we'll be taking on to. So thank you so much. I'll be ending. This is my email ID. If you wish to write anything, I generally reply back within 24 to 48 hours. That's a maximum that I can take on to. You can find me on LinkedIn as well. So any of your doubts, any of your queries, any of your questions, if we are unable to take it here, because we are approaching with the validatory as well, if we are unable to take it here, I will be more than happy in answering you. So thank you so much. And thank you so much once again, JSS Law College and Pro Bono Club. Thank you so much, Dr. Kalpesh sir, for extending that invite. I really hope the today's session was more of how the technological advancement and how my younger generations, for which we have organized this capacity building program for 10 days, would definitely be helpful for. Thank you so much. Any questions or anything that is there, I guess I'll be more than happy to take it.
Yes, participant, any question, query, you can unmute yourself or ask. Any question from boardroom? We'll take maybe 2, 3. Yeah.
Thank you, sir, for your wonderful session. We have one question from the boardroom. Is there a way to merge the benefits of ad hoc and institutionalized ADR mechanisms?
Okay. I guess there is a slight confusion for you that what can be institutionalized arbitration, what can be ad hoc. Always remember, the set of disputes would always be a common thing. It is just an effective way of resolving it. It is just like, I'll tell you, the basic difference is how to put this. Okay, so the basic difference is more like a school and a coaching center. So why I say coaching center, you go to a coaching for like an informal attire in a way, okay, I'm casually going on to. Institutionalized arbitrations comes, okay, you have to come to a 9 to a 5 thing. You cannot enter in between, you cannot go out. You have to be in proper uniform. You will have to follow the rules. You can, the timetable is fixed by the institution. The fees is fixed. The set of subjects are fixed. It's not like I am in class 7th and I want to study one subject from class 9th, one subject from class 8th, 3 subjects from class 5. That is, randomness is not there. So institutionalized arbitration is more of a structured way of settling of dispute through arbitration. The Arbitration and the Conciliation Act would follow in both the places. But it is in an ad hoc arbitration, the arbitrator rules the court. In an institutionalized arbitrator, then even an arbitrator is bound by the rules of the institution. Like, for example, DAC. For example, IIAM, like a private institutional arbitration center. For that matter, IAMC, Hyderabad. Brilliant organization. I haven't seen such an organization with such preciseness. You see their websites, everything is written pre-hand. There is nothing to hide on to. The fees is prescribed. It is presently chaired. Former chair was the former registrar for IAMC Hyderabad was Tariq Khan sir, who has moved to Middle East as a great arbitrator, is now preceded by Jawad sir, who is a renowned mediator in our country, renowned arbitrator. And believe me, you meet any of the mediator in any part of our country, you ask him that the training that you underwent, who was one of the common, and Jawad sir's name will be as common as something. A person who is, I would say, a stalwart in the mediation is presently the registrar of IAMC. See their website, see the website of IAMC, see the website of SAMA, see websites that everything is structured that you just have to enter the dispute. They will, from a panel of 10 arbitrators, a arbitrator will be chosen. The matter would be resolved as per the timelines prescribed in the rules. So everything is so structuredly written that it cannot take. On the other hand, ad hoc is more, as I said in the differences, it's more like how and what the part suits the parties. Okay, we are not able to meet Saturday. Can we meet on Monday? A casual approach of it. Here, if you do not meet, why you want to, there will be a notice sent and all those things are there. So more structured, more easier, more like disciplined way, and how the disputes would be resolved is something that we'll be taking.
Thank you, sir. Since there's a paucity of time, I will request all the participants, if they have any queries, you can reach out to either the organizing committee or sir himself for any other queries. With that, I would like to request Rajeshwari to render the vote of thanks for this session.
Gives me great pleasure to extend the vote of thanks on behalf of JSS Law College on the last day of 10-day capacity building program on ADR, legal aid and allied laws. First and foremost, our heartfelt gratitude goes to our esteemed guest speaker, Dr. Deevanshu Shrivastava, founding dean and professor of law at JL Bajaj Institute of Law, Greater Noida. Sir, we are truly grateful for your presence and depth of your knowledge you have shared with us. Your insights in the topic innovation and best practices in ADR has helped us immensely. Thank you, sir. I would also like to express our sincere appreciation to the driving force behind this event, founder of Pro Bono India, Dr. Kalpesh Kumar L. Gupta. His meticulous planning and dedication are what made today's lecture possible and seamless. We are also thankful to our Chief Executive, Professor K.S. Suresh, and a warm thank you to our respected principal, Dr. N. Vanishri, in their absentia for their unwavering support and encouragement that continues to strengthen our academic initiatives. A special thanks to faculty coordinators, Professor M.P. Nagendra Murthy, Associate Professor, for his constant motivation and support. Thank you, sir. And Ms. Asmatun Ji, Assistant Professor of Law, for her behind-the-scene effort and consistent support in ensuring everything was well organized. Finally, a big thank you to all the participants who joined us and contributed to the success of this session. Thank you.
Yes, thank you, Dr. Deevanshu, and look forward to seeing you.
Yeah, thank you so much, sir, and thank you to the esteemed and respected faculty members at JSS Law College. And thank you so much, my dear students, and I really appreciate, sir. Take it as a compliment from me. I've been to so many places, and I the other day, Kalpesh sir was also mentioning that the discipline of how that number still is 143 is commendable to all the teachings and the learnings of the students at the law school. So please take my respect, take my gratitude, and I'm really humbled and I'm really touched to see that particular thing. I really wish the law schools of our country should be as disciplined as one of these particular things. And I'm definitely going to cite in as an example to any more of it. And Kalpesh sir knows this. One thing that I really learned from one place is definitely a word thing, a best practice, as that was my topic today. This is one of a good and a very, very appreciable fact. So compliments to all of you for that particular.
Thank you, sir. Thank you so much.
Manoj sir, are you there? What did you say?
ಜಾಯ್ನ್ ಆಗಿದ್ದಾರೆ ಇಸ್ಲಾಮಿಯಾದ
ನಮ್ಮ ಹುಡುಗರು ಇಲ್ಲಿ
Manoj sir, are you there?